with coming up with some compromise language that would address the concerns of all involved. My sense personally is that they have done that, and this, of course, we're looking at lines 76 to 84. That doesn't preclude any other changes having happened or members asking other questions either related to that or another section. But with that, Representative Lindsay, let me ask you to go ahead to speak to that compromise, and then we'll see what else is there, and then we'll go to a motion.
76 to 84. There was a good discussion on Monday about this, and I do appreciate the committee taking a look at that. Basically, what we do here is we set out in D, a new D, that the age of consent and the accused lack of knowledge of the age of the person being trafficked shall not constitute defense in the prosecution for a violation of this code section. That's a hard and fast rule. However, for the remaining parts of those defenses that we wanted to limit, we set out something separate in E that simply says that the sexual history or history of commercial sexual activity of a person alleged to have been trafficked or such person connected by blood or marriage to be an accused in the case will not be admissible unless the court finds that the probative value outweighs substantially the danger of unfair prejudice, confusion of the issues, or misleading the jury. And that the court will make this determination in a hearing outside the presence of the jury.
I understand that that'll be consistent with the federal rules if we go ahead and adopt that pursuant to House Bill 24.
Yes, it will.
Okay, great.
It will be, and this is a section that we worked on very closely with both the Attorney General's office, prosecutors, and defense lawyers, and we believe that this is something that all three are in agreement as to how it should be worded.
That's my understanding from communications that I've received from those interested parties. Any questions for the author on that particular section or anything else?
There were, if I may, just real quickly, there were a couple of other tweaks to the bill based on some things that were raised. Let me just very quickly tell you about those. First off, found on lines 35 and 36. We made clear that in dealing with the drug issue, that we added the language for the purpose of compelling such person to engage in labor or sexual servitude against his or her will. We added simply the word labor along those lines. And the additional section you will find, section 10, was language requested from the GBI. We already had some language in there for the GBI to be able to also investigate these crimes. The GBI wanted to have essentially the same type of powers they had in investigations they have in other similar kind of crimes. So we simply just dropped the language that is found in other areas into this section.
And that language is consistent?
Yes, sir.
Great. Questions, Ms. Abdul Salam?
Thank you, Mr. Chairman. I think I heard him say so, but I just want to clarify, this is also consistent with what we were talking about with the rape shield laws?
Yeah.
It's consistent with that?
Well, we tried to as best we could. There is one tweak that there's one area that is a little bit separate from the rape shield law, in that the rape shield law, the hearings have to be held in camera. Okay. Given the nature of these defenses and given some of the U.S. Supreme Court decisions, that'll have to be decided on a case-by-case basis.
By the judge?
By the judge.
Okay.
Simply a sweeping prohibition against an open hearing may be in violation of a Sixth Amendment in certain kinds of cases. So we felt it had to be left to simply the discretion of the judge.
I think that's fine. Thank you.
Yeah.
Thank you. I see no further questions. With that, what's the pleasure of the committee? Moved to pass by Ms. Abdul Salam, seconded by Mr. Pack. Any further discussion on the amendments? Ms. Abrams waves. Seeing none, all in favor of the gentlelady's motion signify by saying aye. Aye. Opposed? No. The ayes have it, and the motion is adopted. Thank you, Mr. Lindsay.
Thank you, Mr. Chairman.
Let me call House Bill 265, Chairman Neal. This is the, Chairman Neal, if you'll permit me, this is the the legislation creating the 2011 Special Counsel on Criminal Justice Reform and the establishment of the Special Joint Committee. I went ahead, as per our conversation, and had a substitute drawn, and I just want to point out the very small changes. They're more technical, cosmetic more than anything else. One of them is substantive, and I'll explain why to the legislation. With regard to the council and the work of the council, a change was made on line 50, moving the report date deadline in heavy bold quotes from January something of 2012 to November 1st, 2011. Upon conversation with the author, we realized that if that report were to come in on time in January, that's at the very beginning of the session. Our experience has been that we do better to have such reports come in earlier in order to afford time and dialogue during the off-season, still during the off-season, in order to determine a plan of action. If it gets here in January when the session kicks in, by definition there's less time and less ability to focus, and this is subject matter that demands focus and it demands maximum time. So with the author's agreement, I put in November 1st, 2011. The hope and the prayer, obviously, is that the report will be done, and I mean really done, by the 1st. If it is not, and let's say hypothetically it were to be about 30 days late, that would still give the Joint Committee the ability over a month to sit in a nice, quiet room and to focus without being pulled in 1,000 different directions about what the priorities should be and shouldn't be, and proceed with a plan of action. The other changes were technical in nature. It had, in terms of the Joint Committee, I should say, it had the chair of the Judiciary Non-Civil Committee acting as the House chair, co-chair of the committee, but not as a member of the committee. So, on pure structure, added the chair of the committee, the chair of the House Committee on Judiciary Non-Civil as a member. Kept the language obviously as being co-chair on the House side, but then added to or struck the number to 16 and changed it to 17, obviously to reflect that change. And that, as I recall, were the only changes. I'm looking at counsel to make sure I haven't forgotten anything, and she's nodding. So those only changes that we have from a structural standpoint on the substitute. Let me ask the author if he has anything to add before we go ahead and go to a motion.
Mr. Chairman, if you're ready for a motion, I'm ready for you to entertain one.
Well, let me say this about the author. The author has been very, very engaged on this issue. This is an issue whose time has come. It's frankly overdue. Mm-hmm. The fact that this is a bipartisan piece of legislation, I want to congratulate and publicly appreciate the minority leader for her participation in this effort. This is the type of Herculean effort that will produce results only with the time and focus of all involved, including our friends and our resources in the judicial branch, and of course the folks we work with all the time in the executive branch. It is a team effort, and my sense of it is that it's very collaborative up to this point. I have no reason to believe it'll be anything other than that as we go forward. So I want to thank the gentleman for his leadership and the time that he has spent in the off-season over the course of several terms, not just in his work with on the meth issue, but doing a deep dive on potential alternatives for punishment for our nonviolent offenders, especially those drug offenders. And I know that's something we're going to be focusing on like a laser. So, questions for the author, Ms. Abdul Salam.
Maybe a typo, Mr. Chairman, but in the summary, I noticed that it says that the committee, the Special Joint Committee, shall consist of 16 members, but in the actual legislation, it says that it shall consist of 17 members. I'm wondering which is correct.
In the substitute, we changed it to 17, and I'll tell you why. In the original draft, it had the chair of the Judiciary Non-Civil Committee be acting as the chair of the co-chair of the Joint Committee, but that position was not included as a member of the committee itself. So in order to chair the committee, you actually have to be a member of the committee. That was it's a technical.
17 is correct?
Correct. That is the correct number. I see no further questions. I'm going to refrain from taking public testimony. This is, by and large, it's a procedural bill. It's an administrative bill establishing the special counsel and the joint committee. Mm-hmm. The sooner we can get this done, the sooner it gets to the Senate, the sooner it gets to the governor's desk, absolutely, and that counsel can go ahead and be appointed and get to work. So with that, let me ask the committee, what is the pleasure of the committee? Move to pass by Minority Leader Abrams. Is there a second? Second by Mr. Atwood. Any further discussion? Are there any amendments? Seeing none, all in favor of the gentlelady's motion signify by saying aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Chairman Neal. While you're here,
Okay. House Bill 199.
House Bill 199.
And Mr. Chairman, I have another bill in another committee shortly, so we had a pretty good hearing of this bill in subcommittee. I want to touch on just a little bit, and I'll be happy to answer any questions. But basically, we have found that there is a real potential threat that's beginning to become more popular within our own state, and that is the use of products being marketed as bath salts, primarily plant fertilizers and other things as well. And basically, what House Bill 199 does is identifies the chemicals that are in these synthetic drugs that are being sold legally in convenience stores and gas stations and head shops and smoke shops to minors, because there's absolutely no regulation on them. And we are classifying those as Schedule 1 in this piece of legislation. And I think this is a very critical piece of legislation. The only thing that I would ask that we do different is consider, instead of having it effective July 1st, I would like for the committee to consider amending it to effective upon the signature of the governor.
Questions for the author? Ms. Abrams.
Thank you, and thank you, Chairman Neal. My concern would be how expansive the use of these chemicals are. Will this interfere with normal commerce and the normal access that people currently enjoy with regards to certain products? Can you talk a little bit about that?
Yes, I think our expert from the crime lab is still trying to get here. She testified during subcommittee. Is she here? Excellent. She can answer this better than I can. I can tell you that they've been very careful with this, but she can speak to any of the specifics.
Let us know who you are. And
Yes, my name is Nicole Astor. I'm the Chemistry Technical Leader of the Georgia Bureau of Investigation Division of Forensic Sciences. Could the question please be repeated?
Basically, are there any normal and ordinary uses of these chemicals that would be now prohibited based on this legislation?
Not that we're aware of. These chemicals are being marketed as bath salts, plant fertilizers, plant food, and aromatherapy. Our best guess as to why that's occurring is to skirt any kind of regulation to the illusion that it might be considered a drug. If it's considered a drug, it has to go through various FDA regulations and be marketed as such. But we are not aware of any legitimate use of these chemicals other than for human consumption.
Thank you.
Mr. Pack.
Thank you, Chairman Neal. Thank you very much for introducing this bill. A quick question. I was not in the subcommittee that's on the other subcommittee. My question has to deal with the scheduling. I know it's Schedule 1, and generally my understanding is that Schedule 1 and going down, Schedule 2, 3, 4, it's based on scientific evidence of addictiveness, how addictive a potential chemical is. Has there been any studies or done by DEA or whichever, the foreign, I know there's a convention out there that controls which drug gets in what schedule with respect to these, the MDPV and, methadone and those type of chemicals. Secondly, if there is a potential, and I'm just worried about the feds coming in and DEA listing this as a different schedule, then you have a conflict of laws issue, and I just want to make sure that we're being consistent with what the scientific evidence is.
Okay. I believe that these chemicals are on the DEA's radar. It does take a certain amount of time for the federal government to control chemicals. To my knowledge, there is no medicinal purpose for any of these chemicals that are listed in the bill. As far as their addiction potential and their potential for abuse, it's simply not known. These chemicals were not marketed for human consumption, so there haven't been, to to my knowledge, there have not been any human tests, clinical studies on these chemicals to determine how they react on the body as far as abuse and addiction is concerned. They were simply shown up, on the market, as an illicit substance that at the current time is not controlled.
Mr. Franklin.
Thank you. While there are particularly children and young adults that are abusing these bath salts and plant fertilizers, we've got people all over the state, all over the country, all over the world that abuse all sorts of substances. I know our neighbors to the north in Tennessee are even thinking of making sure that NyQuil is only available by prescription. That's been proposed up there. And I'm just wondering, how far do we want to go in being the people's savior? I know that people come and pray to us to save them from themselves. At what point do we say the state of Georgia is not God? And
I think that's a great question, and clearly there are times when we have to wrestle with that. But wherever we say that line is, I think when we look at the seriousness of this chemical and the fact that, unlike NyQuil and others, there is no legitimate use for it. When you look at the fact that, for example, Mark Ryan, with the director who's the director of Louisiana Poison Center, said if you take the very worst of some of the other drugs, LSD and ecstasy with their hallucinogenic delusional type properties, PCP with extreme agitation, superhuman strength and combativeness, as well as the stimulant properties of cocaine and meth, if you take the worst of all of these and put them all together, this is what you get. So I think when we're talking about substances that are this dangerous, these are nowhere near wherever that line may be.
And if I could ask a follow-up.
Sure.
Probably one of the most dangerous drugs out there that is called untold death and destruction of individual lives and families is the drug of alcohol. Mm-hmm. And are you willing to bring forth a bill to put it on Schedule 1?
I would recommend that you introduce that legislation if you'd like to. I'm not going to tackle that one.
That was a legitimate question.
No, I'm not willing to tackle that one.
Thank you.
Mrs. Cooper.
Thank you, Mr. Chairman. To the representative, and I wasn't in the subcommittee either, and it goes to the minority leaders. This is not something found in normal bath salts and things that you buy at Macy's or anything like this. This is something that's totally being marketed.
Absolutely.
As something it is not.
Absolutely.
A drug.
Absolutely.
And it's a big problem in Georgia?
It is becoming more of a problem. It is a bigger problem in some of the other states at this point, but it is becoming more of a problem in Georgia. I think that if we can get out in front and get this off the shelves of convenience stores and gas stations before it becomes that kind of a problem in Georgia, then we've done a good thing for the state.
I see no further questions, Mr. Chairman. Thank you. Is there any other individual or entity that would like to be recognized to speak to House Bill 123? No, I'm sorry.
199.
199. That's the next one. Seeing none, let me just ask you a quick question. I realize the GBI has obviously endorsed the legislation. I assume that's been in consultation with our state narcotics agency as well?
Yes.
Okay. I just wasn't sure if that had been mentioned or not.
Yes.
I just wanted to cover that.
Yes.
Okay. What's the pleasure of the committee?
Before, just wanted to remind you, I'd like to see an amendment if at all possible.
We'll get there.
All right. Thank you.
Yes, sir. What's the pleasure of the committee? Mr. Pack moves do pass. Second by Mr. Atwood. Is there any further discussion? Let me ask Mr. Pack to rephrase that in terms of do pass by substitute, and then we'll go. We'll go ahead and put forward the vote on the amendment for the effective date. It's however the council. We usually pass it by substitute. We'll say do pass by substitute, and then we'll go ahead and amend.
This one's a straight bill right now, so it's just a regular pass until you
Oh,
get
right.
the amendment, then it becomes the
What?
I'm looking at it.
Right, right,
Straight bill.
right.
Yeah.
Sounds good. Any further discussion? Any amendments? Okay. Let me go ahead and propose an amendment to change the effective date from July 1st to governor's signature. Any questions or objections on the amendment, Ms. Abrams?
To the author, my concern about changing the effective date is the timing for notification. Right now, it is being marketed as a product that has normal and ordinary uses, and it's being marketed to vendors who may not realize that they are breaking the law. What will be the process for alerting them? Because what this bill would do is it's going to apply to any offenses committed on or after such date, and that could be as soon as 2 weeks from now or 3 weeks from now, and I'm concerned about the timetable.
Let me share with you. You may remember last year we addressed K2, spice, synthetic marijuana, and we did that upon the signature of the governor. And once it began moving through the process, the word got out very quickly among the people that were marketing it, what was happening. And I don't believe that GBI could speak to this if there was an issue. I don't recall there being any issues last year with that legislation of people not being aware that it was no longer a legal substance.
Thank you. I would respectfully object to this amendment because I think that, I think the synthetic marijuana is a very different substance. Marijuana, synthetic or otherwise, is certainly a known issue. And given the fact that while I appreciate the testimony that says that there's no known commercial use for these substances, the absence of investigation, the absence of a great deal of research on the product makes me concerned that we may have some unintended consequences, and this is going to criminalize an activity that's currently not criminalized. And so while I understand the need for haste, I would be deeply concerned about moving up the timetable beyond our normal timetable.
Let me just ask, in that context, would it still be the author's preference to have the effective date on the governor's signature, or leave it at July 1st?
I would prefer that it be on the governor's signature.
All right, I'll go ahead and offer that amendment if there's further discussion on that, Mr. Franklin. Okay, very well. In deference to the author, I'm going to go ahead and offer the amendment to change the effective date from July 1st to the signature of the governor's. There obviously is objection. All in favor of the amendment, say aye. Opposed?
No.
The amendment is rejected. We tried.
And I appreciate that effort. I am much more concerned about the bill than I was the amendment.
I think we all are. Any further amendments, Mr. Franklin?
No. That was from the last time.
Okay. Are there any further amendments? Seeing none, on the motion of due pass of House Bill 199, all in favor say aye. Opposed? The ayes have, and the motion is adopted. Thank you, Chairman.
Thank you, Mr.
Neal.
Chairman. Appreciate it.
Chairman Powell has House Bill 123. We have a substitute in your folder, which is LC 294627S. House Bill 123, the substitute in your folder, which is LC 294627S. Chairman Powell, welcome.
Thank you, Mr. Chairman. This is House Bill 123. There's currently a statute in the Georgia Code, and it's 16-1033, that makes it unlawful for any person to try to remove from a law enforcement officer his firearm, chemical spray, or baton. And what has come to my attention is that firearm is not construed to include a stun gun or a taser. And this came to my attention as a result of a law enforcement officer who had a suspect who wrestled with the officer, tried to get his taser from him and tried to tase him with it. And that was not illegal for him to remove that from the officer, just like it would have been if he'd removed his baton or his mace. And so I'm offering this bill to correct that oversight, and it doesn't change the substance of the current law other than it makes it clear that stun guns and tasers are included in the definition of firearm.
Thank you. Questions, Mr. Franklin?
Thank you. Representative Powell, is there anything in the current code that if someone were wrestling with you and tried to take your stun gun, that they would be in violation?
I don't have a
of any
stun gun,
code?
but no.
But
I mean, it might be an assault. It might be a misdemeanor theft, but as far as it falling under this code section, because this code section only applies if the person is a law enforcement officer, corrections officer, parole officer, probation officer, and the suspect knows or has reason to know that I'm in the course of my employment.
right. So what just trying to look, what is the penalty on that? That's a pretty stiff penalty. But if someone were to try to take your baton that you use for self-defense, or your wife's stun gun that she would use in self-defense, they would not have such a stiff penalty of committing a felony.
That is correct.
If a mere mundane stun gun was taken from them.
That is correct. And Mr. Chairman, I'd point out that in Code Section 161106, which is possession of a firearm or knife during the commission of or attempt to commit certain crimes, in that code section, firearm is defined as including stun guns and tasers, but for whatever reason it was omitted in the definition of firearm in 161033.
Ms. Neal.
Thank you, Mr. Chairman. I think I really appreciate this bill because I'd actually thought about it before as well. But usually if someone is in this position or officers in this position, the person or the suspect is usually trying to prevent arrest or fight for their lives in a sense. So by taking their stun gun, taser, or their chemical agent, if it is taken and used on the officer, it then incapacitates the officer to the point where a person can get their gun and potentially be a deadly threat to them. So just to clarify, I do have an understanding of the bill, and I do appreciate it. Thank you.
You're welcome.
Thank you. Any further questions from members of the committee of the author? Seeing none, is there anyone else who would like to be recognized to speak on House Bill 123? Mr. Ramsey.
If now is an appropriate time for a motion,
It would.
I move do pass HB 123 by substitute, which is LC 294627S.
Mr. Ramsey moves do pass of House Bill 123 by substitute LC 294627S. Second by Mr. Atwood. Any further discussion? Are there any amendments? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it, and the motion is adopted. Thank you, Chairman Powell.
Thank you, Mr. Chairman. Thank you, members of the committee.
Let me tell members of the committee that I would anticipate us meeting on Friday morning, and I would anticipate us meeting on Monday morning. The majority leader, I think you recall, said on the floor that when we go back on Monday, it will be at 1 p.m. So I would anticipate a meeting Friday morning and anticipate a meeting on Monday morning. Notices will go out as soon as possible, and I think what I'll end up doing is having Ms. King just send out a save the date type of notice that we will meet, and then we'll get the agenda out for Friday in as timely manner as we can, and then for Monday as well. And with that, thank you for your attendance here today. There's a lot going on. We're adjourned.